Nature of relevance. So let's revise a problem solving in law question. As previously in law, factual problems are to be solved by what we call ILAC. So first of all, you outline the issues, and then the law and the rules and the application and conclusion. So with the issues, you have to outline the key issue that needs to be resolved. So you need to work out what is relevant and what isn't relevant. What are the issues basically that are relevant? Then you got to delineate the law and the rules. So what the law or rule state. So for example, remember to keep this short. Then you've got the application. So now you've got to apply the law onto the facts, including what differs and what is analogous. Now, this is a crucial step in law, and is usually where students go wrong, because anybody in high school can delineate what the law is, but not a lot of them can apply it well. So if you can apply it well, that's how you can stand out. Now, then you've got conclusion, which is a small conclusion as to what is likely. So you can't say what will happen, because anything can happen inside court, but you've got to say what is likely, because obviously if you say something will happen and it doesn't, then you might be screwed over later on. So what is evidence? Whereas dispute resolution ethics was pre-trial, evidence and proof in theory and practice is now at trial. Yay, we're finally there. So evidence law in South Australia is based on the common law modified by statute, primarily the Evidence Act 1929 in South Australia. The federal or ACT courts, on the other hand, have a law of evidence that is based upon the Evidence Act 1995, Commonwealth, and the court's interpretation of it thereof. So, though the entire evidentiary process is not codified, the exclusionary rules, for example, has been codified into Evidence Act 1995 Commonwealth, Section 56(1). The federal statute is primarily important because New South Wales, Tasmania, Victorian Evidence Acts are codified as a part of the plan for the Australian Law Reform Commission to create a uniformly evident rules around Australia. So basically we refer to the Commonwealth Act as the Uniform Acts. So basically, in South Australia, we use the Evidence Act 1929. However, everywhere else, we just state that it's called the Uniform Acts. So it seems like South Australia's behind. But the law of evidence deals with, once you have a case ready, how you can prove your facts in court, which primarily includes the following. So you've got testimony evidence, you've got documents, and you've got real evidence. Testimonial evidence relates to witnesses to relevant events, documents contain relevant information, and real evidence are the things that can be observed, such as a bazooka used in a murder. Although evidentiary rules apply in both civil and criminal cases, they have greater practical concern in criminal than civil matters. And the reason why it matters more in criminal than civil is partly due to the constitutional right that guilt must be proved beyond reasonable doubt, and this proof must not be based on unreliable evidence. Now note that an error of evidence is an error of law as opposed to an error of fact. So an accused convicted following trial prima facie, so on the face, is allowed that appeal where there is an error of law. So where there is an error of law, usually a convicted person will be allowed to appeal. So that's Criminal Law Consolidation Act 1935, Section 352 and 353. But it can be rejected on the no substantial miscarriage of justice, that is, despite the error, the conviction has been established beyond reasonable doubt, and that's Weiss R 2005. Now, in fact, even without an error, the court has allowed an appeal on the miscarriage of justice, and that's Kotzman 1999. However, the DPP cannot call an acquittal into a question on appeal, and that's Criminal Law Consolidation Act 1935, Section 354. In cases tried in the magistrate, both parties have full rights to appeal to a single Supreme Court judge, and that's Magistrates Court Act 1991, Section 42. Now, the nature of relevance. Throughout the questions, we ask the following questions. So, is the evidence relevant to the material fact? If it's so, then it can be tendered, and that's Uniform Act Section 56. However, is it subject to the exclusionary rules such as hearsay, propensity, etc.? And if not, should the evidence be excluded under discretion such as legal professional privilege? And if not, the evidence is now admissible. So let's start at the top. Is the evidence relevant to the material fact? If so, it can be tendered, and that's Uniform Act Section 56. So relevance is the process of inference, which is, given fact E exists, can the fact F be inferred? Although it needs to throw light, no matter how dim, on the material facts in issue, so that's disputed by the parties, no, it does not need to prove or disprove. In civil cases, pleadings or interrogatories or notices to admit operate to narrowly define material facts in issue. In criminal cases, a plea of not guilty puts all material facts in issue. The accused, though, may formally admit facts under Evidence Act 1929, Section 34, and Uniform Act Section 184. Furthermore, in South Australia, a court may permit prosecution to serve a notice to admit with a threat of unreasonable failure to admit taken into account upon sentencing. That's CLCA 1935, Section 285BA. However, the next question is it subject to exclusionary rules such as hearsay or propensity? So this is if it is relevant. And then if not, should the evidence be excluded under discretion such as legal professional privilege? So Sufficient relevance is that if so little light as it should be practically refused, it will be. And that's R. and Stevenson, 1976, in Uniform Act, section 135 to 136. And you got fairness, so that's Uniform Act, section 135 to 8. Although, note that it isn't prejudicial simply because it implicates the accused of the charged offence. So just because it accuses the charged, it doesn't mean that it's prejudicial. Now, examples of unfairness then are the following. Where the accused is denied of an opportunity to cross-examine evidence, so for example, because the police has unlawfully destroyed cannabis seeds, and that's R. and Loban 2000. Due to hospital delay, accused denied opportunity to test blood sample for an alcoholic content, as R. and Krieg. Though note this decision was not followed in a case where the absence of blood alcohol taken by police is inaccurate. Speculative possibility accused may have been able to challenge evidence does not make it unfair. Where investigators would never have obtained evidence if correct evidentiary procedures had been followed, and as Justice Brennan in Duke and R. And where evidence is merely unreliable, it cannot be regarded as being potentially misleading and excluded, and that's Rosines and Beljajev, unless even with directors, jury might give evidence more weight than it deserves. Evidence in criminal trial must be excluded if it is unfairly prejudicial, that's Uniform Act section 137, or illegally or improperly obtained, that's Uniform Act section 138, unless the court can be convinced otherwise. Then you've got public policy, which we'll talk about on the next slide. However, if not, so if it's not under one of these descriptions, then evidence is now admissible. However, it will be evidence for which a warning or to the jury should be given. So that's the last question asked. So, but we'll go back to public policy. So public policy, Uniform Act section 90, which is the permission to exclude illegally or improperly obtained evidence procured by law enforcement, as Rujwaina, and the Uniform Act section 138. So the improper evidence obtained must be caused or procured by illegality or impropriety. So that's question of law reserves number 1 of 1988 per Chief Justice Doyle. If evidence is legally obtained in the first place, but there was impropriety, denying subsequent testing, not held to give rise to public policy discretion. And it's R. and Loban, per Justice Martin. So where there's legal obtaining, then it's fine, basically, in this scenario. Now, discretion has since found to extend to covering subsequent illegality so closely related to the evidence, admitting it undermines the integrity of the judicial process, and that's R. and Moore, per Justice Chernov and Eames. The court must now consider, in exercising their discretion, and this is Bunning and Cross, the nature and seriousness of the crime, the impropriety alleged, and how valuable the evidence really is, considering whether it undermines the integrity of the judicial process to admit it. Now, note the overlap between fairness and public policy. In cases involving illegality or impropriety, the question to ask is whether the conviction bought at too high a price, giving regard to contemporary community standards of fairness. Now, it is possible to argue, though, that unfairness discretion, where if the police had acted legally, evidence would have never been obtained, should take precedence, and that's R. and Pavic, 1998. Courts, however, have held that if police had acted legally, evidence would have never been obtained, is not decisive, and the court must go on to look at public policy, and that's R. and Swarfield, 1998. Effectively then, because note that public policy can also go against a person, because if it's in the public policy to jail that person, then public policy will prefer that person to be jailed. However, it might be still unfair. Effectively then, fairness and public policy is combined, but only for the confessional evidence, and that's R. and Loban 2000. For other evidence obtained through impropriety, exclusion must be considered on 1, fairness, and then 2, public policy. The court in Police in Hall 2008 agreed, holding that unless there was issues of impropriety, the unfairness discretion wasn't even enlivened. In M&R, however, 3 out of 5 judges refused to place any limits upon the notion of fairness. So the judge and jury, the difference between the judge and the jury is as follows in the court order of process. The judge's role is to determine which facts or evidence should be put forward to the jury, and judges can choose to hold a separate trial within a trial to determine facts upon which admissibility of evidence depends upon, known as a voir dire hearing. The judge manages the case, so as a result, the judge has the discretion to give leave. So for instance, leave is required when party calling witness wants to cross-examine the witness, to cross-examine the accused on prior convictions, to re-examine or recall a witness, or party who wishes to reopen the case. Granting of leave in other directions is formally provided for in Uniform Act section 192, which requires the court to take into account a number of general considerations, of which failure to consider any one of them will provide ground for appeal, and that's Stanovesky and R. 2001. So the extent which decision might unduly lengthen the trial, the extent to which decision might be unfair to party or witness, importance of the evidence, and nature of the proceeding. The judge answers legal questions put forward by the counsel. The judge also summarizes the case and directs the jury upon which facts it must prove find proof and to what standard of evidence must be proved. So, for example, does it need to be beyond reasonable doubt, or does it need to just be over 50%? Including other directions and warnings as required, and comments upon evidence so that no miscarriage of justice occurs. The judge, however, in directing the jury, says as little as required so not to confuse them. There is no need to explain what proving beyond reasonable doubt means, only the need to state it as Green and R 1971. There is no need to analyse particular inferences to direct jury. The jury may need help when counsel refer to indispensable intermediate facts, which requires proof beyond reasonable doubt themselves, if the whole is to be proved, and that's Shepard and R 1990, in order to prevent miscarriage of justice. No mathematical models of probability have been rejected by Australian courts, and that's Adams 1996, having said that DNA alone, which requires statistics, has been used to convict, and that's Forbes and R. Now, without using a mathematical approach, a hypothesis is then formed, only supported with available evidence. For instance, witness account must be credible, or circumstantial evidence that requires inference that there is no competing hypothesis. And then the jury makes the final judgment. So in South Australia, other than serious criminal cases, no jury sit and the judge takes on both roles, but note that it's important not to fuse the separate roles. This obviously may mean a fused single court judge may hear evidence to determine its prejudice, which may subsequently be excluded, thus having little practical effect. However, this discretion though remains.